All right, everyone. It is 11 o'clock, so I will go ahead and get us started. Good morning. I am Taylor Post, Swiftland's office manager, and I would like to welcome you all to today's webinar, Understanding and Negotiating Electronic Resource Licenses, and today's presenter, Dr. Stephanie Rollins. Dr. Stephanie Rollins is a research and writing specialist at the Air University Press at Maxwell Air Force Base. She is also an adjunct professor for the University of Alabama and teaches digital reference, collection development, and organization of information, among other courses. Stephanie serves on both regional and state library committees, and she has 23 years of experience in academic and special libraries. She holds a BA in English from Auburn University, a master's degree in library service, and a doctorate in public administration, both from the University of Alabama. Please welcome Dr. Rollins and enjoy her webinar.
Thank you, Taylor, and thank you, Debbie, for being here today. Good morning, everybody. Today we're going to talk a little bit about understanding and negotiating electronic resource licenses. This is definitely not an all-exhaustive presentation, but kind of to get you familiar and to start thinking about things and how to kind of understand some of the terminology and how to negotiate different things like that. If you would, just for a second, please type in the chat box if you have a role in negotiating or having to work with electronic licenses. I'm just curious how many of you do that, or if you're just plain interested in it or you're going to be doing it at some point. So just talk to me a little bit about what your role is. I'm just kind of interested there. So the hardest thing to me about licenses is that it is a legal contract. And I don't know about you guys, but when I was in library school, I didn't have a class on electronic licenses, or I didn't take the law librarian class. I did, so I didn't have a huge background in this when I started working with it. Okay, so you guys say yes. Robin says she's involved as a public library director. Everybody's typing so fast for me. Fantastic, thank you. So Doris says she does negotiate database contracts for her business school. Shannon says that she handles journal packages. A couple other people are typing. So great. I'm so glad you're here today. And as I talk about things, if you have an example or an experience, please type in the chat box, because that's only going to help other people understand some of the issues with licenses and different things like that. So when I reflect on library licensing, the way libraries acquire basic content for the readers, it's completely upended in the last 2 decades. And I've worked with basically in mostly academic libraries and acquisitions through most of that period. And so I've been in this from the days of the first subscriptions for electronic journals. I'm dating myself now. The old days were good, right? If you were there, some of you. Or at least we understood for decades how the rules worked. Libraries purchased a book, it was on the shelf, users borrowed the item, you made a photocopy of it, and it was under the first sale in the U.S. Copyright Act. So you didn't have any of these issues that we have today. And at that point, the library could purchase another copy or make a reproduction, like I just said. Well, this is no more, right? This does not happen anymore. In this rapid electronic environment, content providers are pressed to enhance and update existing products, or they're super competitive, right, with new products. And they try to increase functionality, they try to increase accessibility, but they have great uncertainty about what users will pay and how much they'll pay. And at the same time, we've got all these new producers entering the electronic marketplace. You've got people that self-publish, you've got people that target our patrons directly and don't even use the library and try to get subscriptions that way. So to me, it's kind of like sometimes we're living in an information Wild West, where we have librarians and publishers are kind of facing off at high noon on Main Street, right? So I kind of get that feeling sometimes. And often, without third-party subscriptions or book jobbers like we used to depend on. Does anybody relate to this, or is this just me? So I just think it's a crazy kind of time, and it keeps getting crazier with all the new products that are out there. So in light of that, what we do have to work with are licenses. And so it's usually a contract between two parties, usually us, a willing buyer, if we have the money, and a willing seller. And the institution has rights, and that's a big thing for me, is we do have rights. We don't have to settle for what just is. We can negotiate. And as with all stakeholders know, there's pros and cons and serious issues along this path that we're on for licensing our content. And so also, like I said, academic authors have entered into the mix, right? So it's exciting. I think it's a very exciting time, but it's also headache making, right? That too. So with that being said, that's just kind of framing it out for you and kind of my experience with licensing and some of the issues and things to think about that I'm sure you're familiar with. But again, like I said, this is a contract. So we're going to look at some terminology. I have about 100 terms. I'm not going to go through them all, don't worry, but you may want to grab your coffee because it's not the most exciting thing. But in order to understand licensing and contracts, there's some terms you just have to know before you can even look at a contract. And so we'll talk a little bit about that. We'll talk about why we have licensing. And I just talked kind of a little bit about that. I kind of alluded to some things there. Some of the types of licensing. What does the licensing process look like? What could it look like? I've got a fantastic example from a California library that I think is outstanding, and they're kind of leading the way in terms of licensing and examples, and they have a licensing toolkit I'm going to share with you. And then I've got some, what does it look like if you just get a generic license? And then talk a little bit about SERU, and I want to ask you guys a little bit about that because my library is not a member. And then we're going to move to negotiation. Why should you negotiate? How can you negotiate? Some examples where this California library has won with negotiating. And then some things I wish I had told myself, or things, if I were writing a letter to myself now, that I would have liked to have known when I first started out kind of doing licensing. So I want to share that with you. And then some resources to help, some books, some websites, some webinars that are free. Almost everything I'm going to show you there is free. I try to focus on that. Okay, so some terms. Like I said, grab your coffee. I'm not going to go through every one of these. Some of these are self-evident and you know what they are. But I just want to highlight a couple of them that you may not be familiar with. And this is linked from the LibLicense website, which is also a fantastic site for getting information on licensing. And they have a huge table of a huge glossary for terms for licensing. So I'm just going to go through a few of these. So acceptance is the formal voluntary act of agreeing to an offer. Affirmative defense, you may not have heard of. Again, a lot of these are legal terms. Again, I didn't have that background before I came to kind of doing licensing, so understanding the terminology is huge to be able to understand a contract. Excuse me. Affirmative defense in a lawsuit, it's a denial, an answer, or a plea that opposes the plaintiff's case and a request for damages. If true, it would defeat the plaintiff's request for damages. An agreement, you guys probably know this one, but I just want to go through it. It's a legally binding understanding and contract between two parties that is often memorialized in a written contract, and a lot of times for us now it's an electronic PDF, right? An amendment is a formal revisions to the terms of agreement. Arbitration clause. Again, this is one you may or may not know. It's a clause in a licensing contract that calls for the parties to resolve contract disputes by hiring a neutral third party to create a binding resolution. So the third party helps them, and that whatever comes out of that is what's going to happen. Authentication, of course, where would we be without that? That's how your library can use another resource that's electronic. It provides access, and it verifies your identity. Let's see what else. Breach is very important, especially in terms of electronic access, because that's a lot of how we access things now. So breach, there's a couple different kinds. And basically a breach is a break in a promise. And it's a failure to perform an obligation that you agreed to. So for instance, somebody in your library, one of your users, downloads 25 copies so he can give it out to everybody in his class, and he prints it. And a lot of times that's in violation of a contract, and it's actually, you'll see it in contracts. So there's two different kinds of breaches. There's a material breach and there's a minor breach. So a material breach is a breach that destroys the contract's value. excuses an aggravated party's further performance under the contract, and gives the aggrieved party a cause of action for breach of contract. So that can be on the part of the vendor or it can be on your part. A minor breach is technically violates a contract term or condition, but does not destroy the contract's value. And they can be rectified with a reasonable period of time, usually. Click wrap agreement or license, that's something that was new to me. It's a contractual agreement that a user views online and agrees by clicking on a prompt. It's as a condition of using or accessing the database or limited resource. So sometimes we see this all the time on websites now with the cookies, right? You accept the cookies, and so it's just kind of a click and you accept. And several court decisions have concluded that click wrap licenses are legal and fully enforceable where a user has an opportunity to review the license prior to using the database service or installing software. So, a lot of times, unfortunately, people just click and download and didn't read the license, and there's things in there that are horrifying. So depending on what you're doing, I would not suggest doing this with a database license unless you read it. And it's good and you accept it and you've protected all of your assets and the people that you want to protect in terms of access and all that. Conflict of law is a judicial decision that determines where a case should be adjudicated. So it's often based on relationship to the transaction. So it may involve things like a contract dispute. It may have to do with a plea. So again, it's sometimes there's a conflict of law when it comes to contracts. Confidentiality is super important to us, and it's the data that we have, people using our resources, what they look up, what they research, and again, it's something important we need to have in our contracts. Course packs. Sometimes people bind copies of materials. There's been a lot of legal suits with this and some of the universities like Georgia. And it used to be we would print things, right, and bind them up from Kinko's, which again now would be FedEx or UPS. And now that people do that online. And so you just have to be careful. Sometimes they are protected by copyright. Creative Commons is a nonprofit organization I'm sure you guys know. They provide free copyright licenses that creators can choose and apply to their works to give public permission to share. There's some different types of damages, which basically damage is a monetary compensation for a legal wrong, such as a breach of contract or a breach of confidentiality. There's a thing called liquidated damages, which is an amount of damages to which the contract parties agree before a breach occurs. A derivative work, sometimes that's important because it's in your databases. It's or some things like you have translations or different things like that. Or motion pictures, recordings, art. So sometimes those are thought of as a derivative work. Digital rights management caused a ton of headaches, right? These are technologies used to control or limit what a user can do with digital media or hardware, such as our ebooks, our ebook readers. For instance, sometimes you want to print a chapter of a book, and it only lets you print like 10 pages, or it won't let you copy or share it. Different things like that. A couple other terms. Let's see. Fair use. Again, it's a defense to copyright infringement set forth in Section 107 of the Copyright Act of 1976. And it allows people to use, access, copy, distribute, remix, publicly perform, or publicly display limited portions of protected material for certain purposes. So if you're an academic library, if you're a public library, sometimes you need to use it for teaching or something like that. Or sometimes if you want to be absolutely certain, you can actually contact the copyright owner and get permission. Force majeure, that's again, Latin legal terms. And basically what that is a contract clause that protects a party from being held liable for a breach of contract caused by unavoidable events beyond the party's control, such as natural disasters or wars. And I think it'd be interesting, not great right now, but interesting to see about how coronavirus has affected some of our contracts. I know a lot of database companies and vendors have opened that up completely because of this. And so I think that's a great thing. But some public libraries, have had to shut down. Some cities and counties have lost the funding for it because of businesses being closed and different things like that. So I wonder if anything's come up with force majeure and some of our libraries. And if you've heard of anything, let me know. Okay, let's see what else. Indemnity is one party's obligation to insure, shield, or otherwise defend another party against a third party's claims that result from performance under or breach of the agreement. Infringement is basically a violation of the law, contract, or right, and a lot of times we see this when we look at copyright. So basically it's unauthorized use of copyright material or the copy owner's rights, and sometimes it can be punishable by actual damages. I think the University of Georgia went through a huge court case when they had a lot of their articles that were put up in their learning management system. So you really, it's hard to understand sometimes, but you just really need to be careful. Let's see what else here. Okay, a license. This is one of our most important things here, right? A license is a right that gives a person or entity permission to do something that would be illegal if the person or entity did not have such permissions, right? So you're downloading an article. Well, the vendor has already gotten the author's copyright permission. Usually the scope of permission includes ownership rights or privileges, what I just said. For example, a license to use digital information gives a licensee permission to access and use the information under the terms and conditions described in the agreement between the two. Again, a license agreement, we're going to spend some time on this today. It's a contract that sets forth the terms and conditions under which a licensor grants a license to a licensee in exchange for compensation, and that's usually a negotiated fee. So the licensee, of course, is the person that receives permission. And the licensor is the person that's granting the license. Super easy. Some of the things that are super important to us are material. It's important, it's necessary, that's what that means. Negotiations, we're going to talk a lot about that today. So what's a negotiation? It's the process of submissions, considerations, and reviews of offers. So you're negotiating on an offer between two or more parties that occurs until the licensee and the licensor, agree on terms and conditions. And therefore you codify the agreement in a contract, right? Or sometimes you codify it and then you mutually agree to end a process without the agreement. And that's totally within your rights. And as you'll see, I'll say later, don't settle. A network is a group of computers linked together that share information. Also, a network can sometimes be a consortia or a group of libraries. A node is a specific connection point. Let me change slides. We're about halfway through. May get a little bit faster because some of these terms I think you just understand. A non-disclosure agreement, we've heard about that with Trump's niece who published the book. But basically, it's a contract or contract provision that contains a party's promise to refrain from disclosing or making public certain information outside a mutually agreeable scope. So again, you want your vendors to agree to a non-disclosure because you want to protect the privacy of your users. Non-exclusive is a status in which the rights the agreement grants to the licensee are available to others. So you can reserve the licensor to give the same or similar rights to use the licensed material to other parties. And that's kind of what we do with library databases. See what else? Permitted use and use. I'm going to talk a little bit about that. Super important to me, and I've struggled with this because if you don't have a great contract and you don't review it and you don't watch out for this, you'll miss it, and that's perpetual license. And a perpetual license is the continuing right to access digital information after the license is terminated. And I think a lot of people have seen with Overdrive or some of the ebook platforms where once you cease using them because of funding or whatever reason it might be, you no longer have access unless you accounted for a perpetual license in your agreement. So that's one of the things on the checklist that we're going to talk about later. Let's see if there's anything else. Servability clause. That's a contract clause that maintains the agreement's legality and continued effectiveness in the event of a court or other trier of fact declares one or more of the contract terms as illegal or otherwise cannot be enforced. This word I can never say, shibboleth, and basically that's an open source project that provides single sign-on capabilities, which is fantastic. And most of us have gone to this, but in the early days we would have, all kinds of different processes for getting on the databases. So basically, it allows sites to make an informed authorization decision for individual access to protected online resources. So sometimes it's done by the address, the IP address of your library, or sometimes it's done by a third-party source. Sometimes it's done by a login and password. And you just have one for all of your databases. Let's see what else. Site license is a particular type of licensing agreement that permits access to and use of digital information at a specific site. Sometimes it's a one site license, it's a consortia license, so there's all different kinds of site licenses. A statute of frauds, and that's a contract doctrine that requires certain contracts will be legal only if the contract is in writing and signed by the party against whom the contract will be enforced. And it's a protection against fraud. Subscription, of course, a type of licensing agreement by which a licensee pays for access to digital information in exchange for payment of a periodic fee. And we guys are super familiar with this. Term is kind of important. Term can have several meanings in terms of a contract. It can be a word or phrase. It can be a clause or a provision in an agreement, or it can be a fixed or definite period of time. Termination, very important. Sometimes we unfortunately have to terminate contracts either because of cost or the vendor relationship with the vendor or the content, right? Termination clause is a term or condition in a license contract that it outlines the date or time period when a contract ends. It may also include a kind of spell out each party's rights and responsibilities that come due when the contract ends or is nearing its end. Something else I want to talk to you about is text and mining data. That's kind of a huge issue right now. And basically, it's the process of deriving information from texts or databases, often by exploring patterns and trends across large databases of content. And our vendors are tracking this. And so it's just something to be aware of and think about. We're being tracked. The Uniform Commercial Code, and that's a law jointly developed by the National Conference of Commissioners on Uniform State Laws and the American Law Institute. And basically what this does is it oversees commercial transactions in the United States, including sale of goods. Sometimes what you'll see is things like the Uniform Computer Information Transaction Act, or UCITA. You'll see that a lot of times in the licensing information. And this is a model law developed in 1999 and revised in 2002 by the National Conference of Commissioners on Uniform State Laws. And basically this regulates software license and database access transactions. So far as of January 2008, Virginia and Maryland are the only two states that have adopted this legislation. So it may be something to look at, our states to look at. So use, one of the last things I want to talk about, and we're going to move on to some of the more exciting content here. So a user is any person who interacts with the database or its licensed digital resources or puts its resources into service. In a licensing contract, the term user, whether it's singular or plural, typically is synonymous with authorized user or end user. So an authorized user is anybody who's mentioned in the license who has permission to access or use the resource. And that's the subject matter of a licensing agreement, basically. It may also be referred to as a permitted user sometimes. Concurrent users is a really important aspect, and that is something that speaks directly to the contract and the price, right? And that's the number of users that can access a digital resource simultaneously. And a lot of things like Overdrive have one user. Some books have 10 users at once. So again, how many people can use it at once? And like I said, it usually correlates with the licensing fee, right? The greater amount of people, the higher the license can be. An unauthorized user, of course, is somebody who doesn't have permission to access. And so there's some different levels there. Sometimes contracts specify that your walk-in users can't come and use the source. So that's things to look at. A waiver is the intentional or voluntary surrender of a known right or privilege under an agreement. A warranty, kind of important. It's a party's assurance or guarantee that a fact upon which the other party relies is true. So you don't have to discover that for yourself. A party that grants a warranty effectively indemnifies the other party from harm if loss of the warranty is not honored. So, for example, a license agreement relating to a database of musical composition samples may contain a warranty that the licensor has obtained from permission from the composers and performers of the individual musical works to provide access to the database to the licensor. So that's just a few terms. Was that helpful? I know it's really hard to sometimes understand some of these contracts, again, without having some background knowledge of some of the terms. Again, there's a ton of things to look at. So any new terms that I mentioned that you hadn't heard of? And again, on the slide, you can actually click on it or all the terms. It's a link to all the terms. And I didn't go over every single one of them. So, okay, great. I'm glad that was helpful. Okay, so I'm going to keep moving on because the next thing I want to talk about is something that I think is super helpful. This is a question for you. So why do we do licensing? What do you think? Why do we do licensing? So I want you to chat amongst yourselves, and I will. I'm going to tell you why I think licensing is important, but I want to know from you as well. And after I did this slide, I started thinking about it a little bit more, and there's a few things I missed. So tell me what you think about this, and I'm going to go to the next slide and kind of tell you what I think. So Bill Gates says that intellectual property has the shelf life of a banana, and I thought that was a really interesting quote because, you know, we have access to these resources for such a short time, such a short shelf life before they're gone, or, you know, we didn't account for perpetual access, different things like that. So people are typing. Angie says because companies require it for DRM purposes. Yes, exactly, because they're only going to give you a certain amount of access to something, so you want to make sure that you have a license that accounts for that, whether you agree with it or not. And you can disagree, and you can edit licenses. That's something I didn't realize in the early days, you know, and it wasn't as bad or an issue in the early days because there wasn't so much that had to go into a contract back then, right? But again, let's see, Holly says protects ourselves and our patrons. Absolutely. I would also add protect the author, right? Protection for both parties. Absolutely. Cost is super important, right? You want to try to limit the cost as much as you can. And as I said in the beginning, sometimes the vendors don't know how much to charge. So what will the market bear? What will your library bear? Sharon also says to protect the owner or corporation in all agreements, it allows the person to amend or negotiate changes. Absolutely. So basically, it's a contract. It's to protect you. Also, in terms of interlibrary loan and resource sharing, you know, you have this great resource. Will you be able to share it with people? Will you be able to share it with other libraries? In terms of authors and patrons, think about privacy and data security. The data that they're submitting when they go to do a search, and their search habits and the things that they're interested in. Also think about, will you have access to these, say, journals or books that you've paid for that period after the contract is over? And a lot of times that's overlooked. And then something that's important to me is equitable service and access for all users. So when you're thinking about a license, you may also want to think about doing a voluntary product accessibility template to include with it. And that's one of the things on the checklist too, is to make sure that you provide access for all, and specifically people with disabilities. How can you make sure that they have access? Jocelyn also says in terms of cost, it's maximizing the resources we can provide for a given cost. Absolutely. Sometimes you bundle, sometimes you do things with consortia. So how can you best get the resources your patrons need and what they want to use, and it's going to help them with their lives, in terms of cost that we can afford. Absolutely. So there's some different types of licenses. So thank you again for sharing with me. Absolutely, Sharon says it helps ensure that the customer gets the best service, access to the products for all. Absolutely, fantastic, yes. So this is a website here at the top. If you can actually click on this now if you want to. But these are some of the different types of licenses that are out there. We have a single academic institution license. And what this website does is it gives you a sample license and template that you can fill out for each type of license. So you don't necessarily have to wait to get a license from a vendor. You can be proactive, and I would totally suggest that. If it's a really simple database, sometimes you can accept it as is. But I wouldn't suggest that. I would always suggest looking through the contract and looking at the license within reason. And it just depends on the license and the product that you're looking at, really. But again, these are some of the different kinds. So a single academic institution license would be for maybe just one product. Academic consortia licenses that's when you go in with other libraries, like maybe the libraries in West Florida. I know Swiftland does some academic consortia licenses on your behalf. Public library licenses can look a little bit different, and I'm going to show you these in just a second. And then there's ones for corporate libraries and special libraries. That's what I've worked in. I've worked in academic and special libraries, and sometimes those can look a little bit different. And one of the reasons for that is because with us, it happens to be that we have to work within the federal government guidelines. And so sometimes we have these resources, but then we have to go out and bid for them. And sometimes it involves the judge advocate general and has to be reviewed by a lawyer. And so the source that you wanted, you may actually often get an alternative. So there's some different licenses sometimes that are involved with that. Sometimes it's an ebook and journal archive purchase. You want to do a backfill on your resources. So that can be possible. Also, sometimes you need a license just for a quick trial. A lot of times I haven't had to do this, but every once in a while a vendor will want you to have a 30, 60-day trial license, which is kind of interesting to protect that for that short a period. So let me kind of show you what those look like. Give me just a second. I'm going to share my screen. you guys hear me? Can you guys hear me or not? Okay, let me try one other thing. Okay, let me know if you can see the screen here too, that we're on the internet. Okay, so you see licensing models? Okay, perfect. I don't know what happened. It completely threw me out, and then I got out of Adobe, and then it had like 50 million windows that opened on top of each other. So I'm so sorry. I don't understand, but we're going to keep moving because I want to get you out of here on time, and I want you to get the information you need. Okay, so I'm not going to go through every single one of these. I'm just going to kind of show you the one for public libraries. But please come back. This is listed on the slide, and you guys can take a look at this. And the volume's okay too because it threw me out and sometimes it affects the volume. Okay, fantastic. Fantastic. Okay, so what I like about this, I am a little bit concerned because it is provided by vendors. So I would still want to check this against my checklist, but it's a good place to start. So let me just kind of show you what it looks like. So this is one for public libraries, and they've also got kind of some instructions here where it says Public Libraries License Commentary. But this is a typical public library license and things that you need to include. So if you're just starting out or if you're trying to look at a license and it's missing some of these concepts or terms or sections, that's something you definitely want to fix. And I'll say this all along, don't settle for just an average generic license that somebody sends to you. Make sure you review it, look at the terms. There may be some outliers that seem weird to you, and you are totally within your rights to question them and ask and negotiate on them. Let's see, so this doesn't look like it's working. Let's see here. Here we go. Okay, so this is kind of a public library license, and I'm sorry since I got kicked out I can't see the delay on here, but you can kind of fill this out. And so you can take the contract they sent you, or you can actually, kind of send them your own contract, and then the negotiation can kind of begin. But this is typically what you'll see in the contract. You'll see the names of the people, the definitions, some of the things we talked about. We talked about use a little bit earlier. And let me minimize my window because I think it's covering up this. But you can see kind of what a contract looks like, how much you're going to charge, some of the premises, some of the staff, licensed materials, about the patrons that can use it, whether or not you have a secure network or server, the subscription period, text mining, whether or not that's allowed. Then you've got an agreement for the terms. You've got some usage rights. And so it just kind of gives you things about resource sharing right here, whether or not you're going to do that, whether or not that's allowed. Again, that's something you can negotiate. What is not allowed in terms of use. And again, this is something you want to look at because it may be important for your library to be able to do an interlibrary loan with this resource. Some of the things the publisher is going to do on your behalf. And I'm just looking here to see if there's anything about, in just this generic contract, about accessibility for patrons with disabilities. Let's see. So there are things. And then watch for things that are all in capital letters. You definitely want to check those. So this one says that the publisher makes no warranties of any kind. So you want to just kind of look at things like this. Things that the licensee will do. And things about termination. So you can see this is kind of lengthy, and again, it's something that you want to definitely review. And so then you've got your name and your signatures, and that's just kind of really basic, very quick, what a public library contract looks like. So I'm going to stop sharing my screen and go back to the slides. Give me just a second. Hopefully this will come back. Okay, so again, like I said, these are some of the different types of licenses. They're kind of generic, and it's something that you can fill out so you can be proactive. Even if it's not something that the vendor accepts, you can totally have something to start with in terms of negotiation because you've got it written out. You've got kind of what you want. Okay, so what does the licensing process look like? And I think this is also important. So one of the things before you even get to the license part, right, you want to look at your collection, you want to look at your users. So important to do that before you even get started with a license because you may get a great deal on something, but if it doesn't fit your collection, it doesn't fit your patrons' needs, please consider that. You want to assess the user's needs, you want to identify the resources, you want to prioritize it among your other sources, and you want to think about your budget. Do you have the money for it? Can you get the money for it? Do you need to do a grant? Things like that. And then you need to get approval to proceed, whoever that might be that does that. Sorry, Faith, you have to leave. Anybody else have sound issues? Okay, so not now. I think when I share my screen, something with the internet just really is not happy. So I will try to talk clear and loud, and hopefully that will come through. And also, I know in the recording it sometimes smooths things out. If you would like to watch it again, hopefully that won't happen again. So some of the other things you need to do is you need to look at your business and technical requirements. So some of the things we just talked about. Does the source provide for perpetual access? Do you have any kind of discount that you can get? You know, maybe there's something you can do where you add on a specific database to your database and you get a discount, you bundle it. Or maybe you add a campus, or maybe you add a local library that's near you. You kind of do a consortium. You want to look and make sure that there's no or there's low ongoing maintenance fees, that you can ensure that there's going to be a cap, you know, on inflationary annual increases. Like sometimes I know some databases have gone up 200%. What's that about? I mean, so you want to see if there's a way that you can look at having a cap on the increase in price. You want to have unlimited access, and you want to look at, you know, that there's no restriction or cancel subscriptions for print and other formats represented in the proposal. So they're not going to cancel 15 titles on you, kind of thing. You also want to look at the licensing terms. What does it say? What are the terms of the license? Is there a discount for open access? That's something you wouldn't pay for anyways. So if they're going to process open access, you want a discount for that. You want to evaluate the quality of the resource, and you also want to look at whether or not there's any reservations with copyright, interlibrary loan, and the fact that you have the right to the content. And then a lot of times what you'll do is you'll do a trial to see if it meets your needs, if it's got the proper computer support, people can access it, it fits their needs, those kinds of things. And then it goes through an approval period, which you have either recommendation to purchase or not. You have to find the funding, or you've got the funding, whatever that looks like. And then you get the contract. And this is where you negotiate the terms. So you discuss the terms with the vendor. Either you have a contract, they present you with a contract, or both, and you can negotiate. So you can send them a standard license agreement. You can make one for your library that you use. That's for all your journal purchases, or your sorry, I just knocked over my lamp. So for all your computer purchases, or one that you have for journals, one that you have for ebooks, whatever it might be, you can have that ready. And so that's something that you can do proactively. You don't have to wait for them to send you a license. Then what you can do is you can have a letter of intent. So that's something that you can, I don't think we talked about, but a letter of intent is something that you can have written, and what that does is it lets you use the database while you're finalizing your contract, and some vendors will do that and some will not. Has anybody ever done a letter of intent? No. Okay. So something that you might want to put in, Okay, so Sharon says she has. Some people say yes, some people say no. So very interesting. If you want to comment in on that in the chat, it might help other people. So that's kind of what the process looks like. So we've talked a little bit, we looked at kind of one license really quickly, but what are some of the things to include in a license? And if you want to type in the chat box, that would be great. Of course, I'm going to cover some of the things you need to check for. And this is again from the California Library, the Digital Library, and they have a fantastic list. And maybe not everything applies to you, but there's things you want to look for. And again, if you draft your own license, that you use as a template for negotiating, it's going to go so much better for you. So some of the areas to look for are the content and access, the actual licensing, the business part of it, and the management. So what does that look like? So some of the checklist things you want to think about are archiving. This agreement should clearly state archival responsibility and may or may not let you copy data for the purpose of preservation or for a usable archival copy. If it doesn't permit that, then the agreement should specify who maintains permanent archival responsibility for the content. So therefore, an electronic journal subscription should include one print archival copy, and you can write that into the contract. Perpetual license. This is huge for me because I've been trying to help somebody, and we had this contract, and then for some reason perpetual access wasn't included. We didn't have a print copy of the journal, so we were done. We had to go through interlibrary loan. Again, sometimes that's not free, right? So those are things to think about. And so perpetual access represents a significant and permanent asset for your library. So you should include a non-exclusive, royalty-free perpetual license that survives any termination of the agreement. And this is something you should definitely include in your contract. Again, you have permanent rights to use this when that you've paid for, even if it's canceled or removed. And so again, you can write that language in there. Another thing you want to look at is the completeness of content. If it has print counterparts, the electronic content should be available before or no later than its print equivalent. And how many times have you seen EBSCO do an embargo, right? So that's something, again, you can write into your contract. And if it's not the case, then the vendor should notify the library when the electronic version contains more than the print. And that's something that I've seen too. So some other things to think about are the link to and from content, right? So if you have a citation, it should link to the full text, right? That's how it should work, and that's something you can write into your access. And also, it should have a permalink. It should have a link that you can go back to, and also, a notification procedure when new titles are added is also important, and those links work. Server availability and performance. So that's on the vendor. They should provide reasonable assurances that the availability and performance of its servers, excluding disasters, right, because those happen, could be available 24 hours a day, 7 days a week, 99% of the time, and you can write that into your contract. If they expect, or we expect as a library, to receive continuing improvements and updates to the interface. Okay, so in terms of licensing, permitted uses, the agreement should not restrict the rights of the library or its community permitted under copyright law. Permitted uses, again, you can look at interlibrary loan. The agreement should describe the permitted interlibrary loan use in detail. Vendors can be really lousy about knowing when a license is about to expire. So I didn't even mention it in this presentation, but there's some electronic resource management tools. Some of the library suite software that's with your ILS has that installed, and you can actually put your licenses there, and it will remind you when you need to start looking. But if you don't have that sophisticated service, then good old spreadsheet with a calendar when is the licensing going to be due and expire and different things like that. So thank you for pointing that out, Chris. You do need to have a management system and pay attention to when things are going to expire, and we are so busy. That's just not always on the front of our minds. But again, to protect yourself, your library, to be accountable, you want to make sure that you have a way to track that. So thank you for mentioning that, Chris. Let's see what else. So permitted uses for interlibrary loan, course packs permitted, or electronic reserves. Those are things that some of you deal with, some of you do not. Classroom use, right? You want the things like videos. You want to make sure that's written into the contract. We ran into that at Samford University. We wanted to share a video with the class, and the way the license was written, it was prohibited. I mean, what's the point of having that service if you're not going to have all of these ways that you can use it? So again, you want to pay attention to that in the contract. And again, of course, just your basic authorized users. Who are they? You want to make sure that you specify that. If they're on-site, if they're distance learners. Our library has about 5,000 distance learners. So those are counted in our total. We have people that come for 8 months and then they leave. So those are counted in the total. So what does that mean for you? What is an authorized user for you? And you want to make sure and spell that out. Also, public workstations at Samford, because we were open to the public, they could come in and sit down and use a database at one of our online computers right there. And alumni could as well, although alumni were not factored into our authorized users for remote access. So you want to make sure and specify that, because that's a different way of accessing. How are they going to authenticate? What is that going to look like? How is the vendor going to support that? Are you going to look at IP access, or is it going to be a login and password, which can sometimes be cumbersome, right? So how are they going to how are you going to do that? You need to spell that out. So the parties to license. The parties to license or authorized users may not be a party to the license, and the library cannot take responsibility for the actions of authorized users or any third party. So you need to think about authorized users and the licensing with that. Sometimes there's dual licenses. You want to make sure that you don't do that. So what that means is the publisher or vendor should not cause authorized users to enter into agreement with the publisher. Basically, those things like we talked about with the click-through, right? Independent of the institutional agreement. So you want to specify that in your contract. Also, termination of access. You want to look at if there's a suspected violation, the publisher should give 15 days notice prior to terminating. And you can even specify in your contract that you want 30 days to cure the violation before the license can be terminated. So that's in things like when people decide to print 25 copies for their class, different things like that you can't always control. And a lot of that you can try to counter with user education and educating your librarians and different things like that. The license posting. One of the things you can do on your website is post the license with redacted information, and I'll show you that in a little bit. And Sharon says they usually ask for 30 days to ensure a smooth transition. Absolutely fantastic. Those are things you can set that aren't usually contested, right? Some of those things. Some other things are. Really important to me, because this is one of my side topics that I talk a lot about, and it's what I thought I might be doing when I started out as a librarian, and that is working with the ADA and patrons with disabilities. And my career didn't take that turn, but it's super important that the data that's presented in the database is accessible and compliant with the Americans with Disabilities Act, and also the World Wide Web Consortium. I did a whole webinar on that and what that looks like. So you want it to be accessible. And one of the ways you can also do that is to include a VPAT. I don't talk a lot about this in this presentation, but that's basically something you can ask for from the vendor that talks about exactly how they meet these guidelines for the web for people with disabilities. And you can take care of that. Okay, so one other thing I want to talk about real quickly, and I pretty much have only about 5 more minutes if you can stay with me. If not, the recording will be here. And at the end, I'll also post a link to the slides that you can share among yourselves in case you wanted a copy of the slides. I didn't quite finish with this, but there's things like indemnification. What that looks like is If you may not enter an agreement that exposes your library to liability. So you can actually specify what that looks like. And there's a link to this if you'd like to look at it. Also, you want to think about content and access in terms of pricing for your journals is separate from the pricing from the database. That's something you can specify. And you also want to look at all electronic resources that does not limit the number of simultaneous users, especially if you share among campuses or among libraries. You want to make sure that it's unlimited. Also, you want to look at in terms of cancellations, and cancellations in electronic journals should be able to look at by title. That's something that you can specify. And you should also be allowed to be able to use a subscription agent if you would like to. So those are things that you can look at. A couple more things. We're going to breeze through this so I can get you out of here on time. But also thinking in terms of the site. What do you define as a site? Is it each library? Is it each campus? Things like that. And sometimes you have to extend your services. Is that something you could write into the contract? Maybe to a research agency or something like that. Also, you want to specify use data, that you get use data, because you want to know how the database is being used. And in the beginning, when we did this, there wasn't a lot of use data. So you want to make sure that you get that, because you're accountable to your board or your administration and also to your users. So you want to make sure that you get the data that you need to support this database, to support continuing it, whatever it might be. Renewals. You want to make sure that the library, and write this in the contract. I think it was, I can't remember in the chat, but talking about managing your time and things like that. Make sure that you advocate for a 120-day notification, a renewal notice, and that's something that will help you as well. URL checking. They should do that. They should provide persistent URLs, so you can put that in your course, or you can share it with a user that's doing research. You can make a research guide. They need to have persistent URLs, and they need to work. There shouldn't be any configuration on your part to do that. And also customer support. They should be available to provide help during standard business hours, and you can specify that in your contract. So just really quickly, I wanted to talk to you about the live license model, and I'm going to demonstrate that to you in a second. There's also the California Digital Library, and I'm going to demonstrate kind of what that looks like. And this checklist is based on what their template is that they send people. This is a public view of their template. They include a couple other things that are probably PII and public information. But I did want to kind of share with you what that looks like. And then, what do they get when they get an agreement? What does it look like? Sometimes you do get those kind of generic standard agreements. And like I've said from the beginning, don't settle. Don't settle for what they give you. You can totally take that, put it in Word, redline it, track changes, send it to them, send it back. You don't have to settle for what they send you. So I'm going to talk about CERU real quickly. Do any of you enter into CERU agreements? Have you done that? Please just type in the chat box. I just want to know. I don't have any experience with it because we've never been able to do this as a government library. No, people say no. Well, apparently it's a way to kind of simplify your agreement. You can sign up for free. You can take a look at it if you guys would like to. But basically what it is, it's a shared framework of understanding and good faith. And so you don't have to go through this negotiation licensing kind of issue, because it kind of is an understanding that the acquisition and acquiring the product, the use of materials, the inappropriate use, confidentiality and privacy, the performance, all that is set. So you don't have to negotiate on it. And so that may be something you want to look at. I don't have any experience with it, but again, it may be something that your library can use to kind of streamline the negotiation process and still respect the user's rights and your institution's rights. Okay, so let me kind of show you I'm just going to show you the California one just in terms of time. So give me just a second and I'll show you what that looks like. So can you guys see? Can you guys see my screen? Can you guys hear me and see my screen? Okay, fantastic. Sorry, we just have to do that now because it's not working like it usually does. So this is the California Digital Library, and I just want to show you kind of quickly what their that's a licensing checklist. Here's their standard licensing agreement. So it may be something that you want to start with for your library and create your license template. So let me do this. Give me just a second, and I'll share it with you. That's not it. Sorry about that. Let me just open it here. Give me just a second. Sorry it's taken so long. So everything we talked about in the checklist is included in their standard license agreement. And they have all this online for their vendors to look at. So you have an information gateway for vendors. So again, it streamlines the process and sets up the expectations in the beginning about what you are going to do, what you're willing to do, your terms. So you've already kind of got that set up. And I just think it's kind of a fantastic approach to use. So hopefully my Word will open quickly. If not, we'll move on. You guys can come back and look at this. I'm just going to skim through it for you real quickly because I know you have to go soon. Okay, so again, this is what their standard agreement looks like. Again, it's a template that you can use. They've got the grant of license, the ownership of intellectual property, how the network's going to be accessed, the fees and payment, authorized users, and again, they mentioned those walk-ins, the IP addresses, that's how they're going to access, the digital copy, the print copy. So I just think it's a fabulous thing to, they talk about classroom use. I think it's a fabulous way to kind of approach and be proactive about your licensing. So I'm going to stop sharing. I'm going to come back really quickly. Okay, so we're going to talk a little bit about negotiation and why you should negotiate. And to me, it's really tied closely to the same reasons that we looked at for why you should have a license. Again, the cost, the accountability, all those things that we talked about. So how do you negotiate? How do you do this? So what are some of the things that have worked for you? What are the things that you've done that you've found to be most helpful? Just please chat type in the chat box while I'm kind of going through this because I think it's going to help you guys. So how can you negotiate? So there's some different things that you can do. One of the first things you need to do is you need to prepare to negotiate. So what does that mean? What that means is you need to learn how your vendors operate, talk to other libraries and librarians and find that out. Be aware of the differences between vendors. You want to do your research. You want to look at that. Decide on your goals before beginning the process. Review the data. So it's not just the content, it's kind of the whole process. Decide who needs to be included in the negotiations on your staff. Have pre-meetings of your stakeholders to identify issues. If it's sometimes you need to have a couple of different people, like your collection development librarian. You need to have your budget person. Sometimes you're a small library and it's just you and one other person. So those are things to think about. Keep notes because you're going to have to do this again. Always document this. Keep up with developments from vendors to ensure that you can know what's going on with them. If they had some sort of buyout, those are all things that you need to know. And again, you want to monitor this. You want to invest in the relationship with honesty and directness. So those are some of the things you can do to prepare. And then what's your leverage? The volume of your business could be leverage. The nature of the mix, the type of publisher. If you do a prepayment or deposit, I don't know if you guys still do those kinds of things. Chris, it looks like you're typing, but you're stuck. So if you need something, please let me know. The reputation of your library. If you're a big, huge library like California, you can really do some negotiating. So keep that in mind. Especially if you're like a member of a consortium, sometimes that helps with negotiation. Also, services from other vendors. And then how you're going to acquire it. Is it approval pen? Is it, acquisition on demand? How is that going to work? And then there's some negotiation points that you can look at. Can you look at things like delivery time? Those are things that you can negotiate on. If it's a fixed or a firm discount, if there's a service charge, you can also sometimes include postage, different things like that. Invoicing, you can include their services as part of the negotiation, that you can get a discount on that. You can also look at reports. How are they going to do reports and claims and claiming services? Those are all things that you can look at and negotiate. So those are some points that you can look at. Again, you can decide how you're going to approach the license. Are you going to wait for them to send you one and edit it? Are you going to accept it as is? Or are you going to be proactive and have your own license template for things that you want to be included? So what are some of the qualities for success? Good communication. You want to avoid misunderstandings and mistakes. It's a joint interest for both of you. There's the success of both of you is essential for survival. And it's this understanding of each other's needs, but also your limitations. And that helps you reach an agreement. And it's also about trust, right? Neither side is in complete control of the situation. And it's about flexibility. You want to, achieve goals, and you want to foster a good working relationship. So that's just a little bit about negotiation. And then I would add, obviously I've kind of alluded to this already, but document the process. Whether it's you're not going to be there, you get promoted, you become part of a different library system. Life happens. Document for the process for the person coming behind you. And even if you don't have those sophisticated systems like Alma, right, that has all that built in for you, you can do something as simple as a notebook, right, an online notebook that keeps copies of your licenses. And that's what I ended up doing for my library. And you can keep notes there about the people, about the relationship, about what went well, about things you want to try to negotiate for the future. Okay. So the last thing I want to talk about is, and I'll actually show this to you about the big win, because I would just want to share once and then come back to you. But I want to talk about things I wish I had told myself, and maybe this will be helpful for you as well. So some of the things I wish I had done. I wish I'd gotten training early, and I would stress to you to continue your training. So if I'd had a crystal ball, this is what I would have done. Keep continuing your training. There's always free training. I'm going to share some of that with you at the end very quickly. You want to monitor trends. What does the database landscape look like? Do your reading, do your research. Consider trying to be part of a consortium to save you money. Sometimes it can backfire, and it costs even more money than just doing it on your own. So that's also something to weigh against. Sign the license as is. I know I've talked about being proactive and marking things up and all that. What the heck is Stephanie talking about? But what you can do is explore things like SERU, and that's one of those cases where you could sign the license as is, because that understanding is there. It's been negotiated. You're set. You don't have to negotiate. Everybody's going to come out happy. Also, ask for legal advice. If you have somebody, you can ask for help. And then, like I said, you want to educate your users. If you notice somebody that's, a faculty person who's putting electronic copy in there, you want to educate your users that They can't do that, but what they can do is put a link. They can put a link to it. So it's always constantly educating our users about licensing. And then also preserve for the future. We want to ensure that perpetual access so we don't lose our resources. Again, I think it was, I don't remember, I'm sorry, but we talked about, making sure you get notices for, renewals and things like that. I would also say, make sure you review your contract that you signed and look at the new one and look at it closely. Don't assume that things are going to stay the same, because vendors they're a business and they're trying to make money. Unfortunately, I hate to sound cynical, but you want to look at that new contract and make sure it still meets your needs. Don't just assume the status quo. And you want to cultivate those relationships with the vendors. That's so important. You want to create these lasting relationships so that you don't have to reinvent the wheel the next time that you start this. Even if it's a new person, you say, well, I've worked with so-and-so and this is how we worked and this was our relationship. And you can kind of set that up so you're set up for success. Okay, so I want to show you cases where people have won when they negotiated, and then I'm just going to show you a couple resources and then we're done, so maybe 3 minutes tops. So let me share my screen and hopefully this will go well. Just 1 second. Okay, so one of the resources here, hopefully you can see this. Can you guys see the licensing toolkit on the screen? Just a quick yes would be great. Okay, fantastic. So let me show you a couple resources very quickly. I'm not going to go into in depth, but I just want to show them to you. This is LibLicense, and again, they've got a license you can look at. They were one of the first people that did that. They also have software over here so that you can download. This is all free. So instead of kind of taking a Word document and trying to edit it, it actually takes you through the process of doing a license. You just want to make sure that you have all the sections and terms that you want kind of in mind before you do that, because you may have to add some things. What I wanted to show you about was the big wins, or actually I wanted to show you kind of where you can get examples of all kinds of licenses. So remember I told you California put up all their licenses. So these are all the licenses that they have subscribed to, and they are a huge institution. So you can actually see the licenses that they've agreed to. Some of them aren't their proactive license that I showed you earlier, but you can kind of see some of the terms, and the things you won't see are like the cost and the people. They've redacted that, but it gives you a good idea for what things and what terms you can look at. This is information about CERU. This is all listed on my slides, so you can look at it. So here's cases where they're having a challenge with licensing from some publishers, and then they also have some successes. So here's some of their current challenges. They have a challenge with MLA, and they tell you what it is. And then here's cases where they've resolved it, and you can look at what happened. And they've also decided, hey, well, we're going to cancel it. And then, of course, when you cancel, sometimes that can be part of your negotiation. This is the LibLicense project site, and all of it with the terminology that I went over. This is a little bit about the Guide for Fair Business Practices for Legal Publishers from the Law Library. That might be something that helps you. This is some resources through the American Library Association, and I've linked this on my slide. It's got some best practices. I also wanted to mention, I think in your area, Claire Dysart, I think is her name. She also teaches 2 courses for ALA on understanding licensing and also on negotiating. So they're 2 4-week classes I would encourage you to check out. I took both of them and they were really helpful. This is information about licensing from the Association of Research Libraries. And they've also got a license that they're kind of have a model for, some principles for electronic licensing, electronic resources, some transparency and pricing. So that's something you can come back and look at. Also, this is a search from the American Library Association for their store. They've got about 20 books on licensing, negotiating licenses. So it may be something that you purchase. This is not free, obviously, but one book that you might purchase that would be helpful. And then the last one I want to show you is this is a book written by somebody I worked with, and it is a fantastic resource for negotiating, not just for your library, but also other areas in terms of negotiating. And I just wanted to see if I had the table of contents here for you. I don't see it here, but you can go and look at that. But they've got working with database vendors, they've got working with serials vendors. So again, a bunch of resources that would kind of help you. I'm going to stop sharing my screen because I just want to mention one more thing to you before we go. Okay, so again, these are the resources that I mentioned earlier, some sources here. And then I just wanted to mention there's some resources on managing electronic content, managing licensing. These are all pre-recorded seminars from Swiftland that you can have access to. Also, the Florida Library Webinars has one. And then these are a couple that's one that's free from ALCTS. And then the last thing I would tell you is thank you guys very much. Thank you for dealing with the technical difficulties. I'm going to paste the link for the slides in here really quickly that you can get to. And if you have any questions about licensing or experiences, if you just want somebody to commiserate with, please don't hesitate to contact me, and I would be happy to talk to you. So here's a link to the slides, and please contact me if you need help with anything. If you have any suggestions, please let me know. Please follow up on the resources. I think they're super helpful. And don't reinvent the wheel because I think there's so much work that's been done out there by the LibLicense people and the California Digital Library that we can look at and learn from and kind of make sure that we do better so we're accountable to our users and our administration, and we're financially responsible and efficient. And we also ensure equitable access for all. A lot of times that's dropped out of the contract, so I'd say definitely please focus on that. Thank you very much for your patience today. I enjoyed talking to you, and again, check out the recorded content because a lot of times that smooths things out, and especially for people that had to leave early. So thank you very much, and have a great weekend. Be safe. Thank you, Debbie.
Thank you, Stephanie, for an informative webinar. As always, we encourage you to keep an eye on the Swiftland CE calendar, the Swiftland Facebook page, or your message from the listserv. Thank you everyone for attending and have a great rest of your day. Thank you, Debbie. Thank you, Stephanie.